What's going on YouTube? Rochasaurus here with another video update. We have Ironmace has to show up to court soon. Nexon's order is granted and they are being fast-tracked right into court. Let's check it out. Let's go!
Hey, what's up everyone? My name is OnePeg, and in this video we actually have a court order from the Seattle, Washington court in the case of Nexon versus Ironmace Games. Very recently, Nexon filed a suit against Ironmace Games seeking not only damages, but have Ironmace completely shut down operations by claiming that Ironmace has stolen IP from Nexon and is now copying their game project P3. Now, for those of you that have been following right along, I'll spare you all the details. For those of you that haven't, if you want to go and check it out, you can check out all the documentation along with all of the videos, obviously, on YouTube and my Patreon page.
Make sure you guys sign up for his Patreon. It's only like $3 per person. He paid like over $50 to print off these copies and get this information out to you guys. So make sure you go ahead and show OnePeg some support. It's not very much money at all, and it helps us keep making content like this that I can react to.
Patreon.com/real_OnePeg. Now, this order has to do with serving both Terry Park and Mr. Choi in...
Which are the heads of Ironmace, if you guys didn't know.
South Korea. Now, they sought an ability to do that via electronic means, which, from what I gathered and research that I've done and talking to other folks in this space, is not something that commonly occurs. But in this case, they actually approved it. And there is a several-page document going into what the judge's thoughts were. Now, this was filed...
This is going to get interesting. I'd really like to see what the judge's thoughts are on this case here. This is what I've been waiting for. Like I said, I predicted that they would have to hand over the code, the source code, and like that would be the final decision factor for all of this, like whether or not they stole company code and trade secrets. So let's go ahead and find out what's going on.
About 7 hours ago. It's about 2 a.m. on the 24th, my time anyway, and this was filed on the 23rd. Here is the document, and we're going to go through this and just kind of read it along and give thoughts and, you know, all that stuff. Anyway, this matter before the court on Plaintiff Nexon Korea Corporation, ex parte motion for alternative service of process pursuant to Federal Rule of Civil Procedure. Plaintiff seeks authorization to serve defendants and its employees, Juhin Choi and Terrence Sangwa Park, collectively defendants, via email, direct message to their social media accounts, and email to Ironmace's counsel located in the United States. Having considered plaintiff's submissions, the governing law, and the balance of record, the court grants the plaintiff's motion. Now, this is very important because this means that the case is likely going to be fast-tracked.
Yeah, it's on the road to fast-track.
The reason why they're looking to do this is because Nexon is very fearful that Ironmace will end up releasing this via their own platform. Remember, Ironmace is...
It's very possible, too. But this is what I was wondering. No, I actually turned captions on. My bad. But what I was wondering was, like, we seen the collector set just get launched this morning, as far as pre-sales go, that they're partnering with that coffee company. If that stuff is being released, does that mean this game is still going to be able to come out? So that's what I'm kind of wondering here. Even though it might not be on Steam, can they still sell it on another platform?
Is still trying to get this to some form of early access and playable version. And the only way to do that right now, due to the DMCA strike that exists with Valve,
that's what I was wondering.
To release this likely via their own launcher and through a pay program like Zola, for instance, similar to what Battlestate Games does with their game. So naturally, Nexon would be looking at this as something that they would want to try and stop. Nexon alleges defendants misappropriated trade secrets and violated its copyright in developing the video game Dark and Darker. Nexon contends alternative service is warranted because defendants are located in the Republic of Korea and plan to release Dark and Darker before Nexon could complete service by means of the Hague Convention on the Service Abroad of Judicial and Extrajudicial Documents. To be honest, I haven't even read this yet. We're kind of just going off the cuff. But that is the reason why they're trying to do this. They don't want Ironmace to issue the game and then have them be making money from it.
Well, yeah, of course. Yeah, anything to prevent Ironmace from making any sort of money off somewhat idea that Nexon had, right?
That before it occurs. And just as a quick side note,
I'll be honest, guys, I don't care. I try to stay unbiased on these certain situations, like for this and this, but like through all in all that we've covered on Ironmace and Nexon with Dark and Darker, I'm on Ironmace's side like 90%.
people that have said, well, I don't understand why Ironmace hasn't responded to this yet. Well, in the case of court proceedings and process in the United States, they don't have to respond until after the summons has actually been served to them. The response doesn't actually get generated until they're supposed to appear in court. So I would expect that we will see something to that effect in the next month or so. Now remember, once they're served, they have 21 days to appear. So there will be a date put on the court.
21 days, holy crap. That means they should be in court in like less than a month, guys.
Court calendar somewhere within the next month. It will likely end up being that they will have to appear, at least even electronically, before the end of June. Ironmace's website lists a business address in Korea. Nexon alleges in its complaint that Mr. Park is the co-founder and CEO of Ironmace and Mr. Choi is the managing director. Mr. Park and Mr. Choi are former employees of Nexon, and according to Nexon Human Resources records, their home addresses are in Korea. An October 2022 social media post by a user whom Nexon has identified as Mr. Park on behalf of Ironmace states, "We are hoping to go to early access in April of 2023. Other social media posts identified as made by Mr. Choi and Ironmace indicate a goal for a complete game release of Dark and Darker in the fourth quarter of 2023. In March and April 2023, Nexon's counsel James S. Blackburn issued takedown requests pursuant to the Digital Millennium Copyright Act to several platforms, which subsequently removed Dark and Darker. In March of 2023, Mr. Blackburn sent cease and desist letters to Ironmace, Mr. Park, and Mr. Choi via email and certified postal mail. Now, there is a subnote here. Nexon alleges in its complaint that Mr. Park is a United States citizen with a residence in California as well as residence in Korea. Nexon has not indicated whether it attempted service in California. For purposes of this motion, the court accepts Nexon's representation that Mr. Park is currently located in Korea. On April 12th, 2023, Ironmace's Korean counsel responded to the cease and desist letter in an email to Mr. Blackburn. Nexon filed the instant suit on April 14th, 2023. On April 17th, 2023, Nexon sent an email to Ironmace's Korean counsel's email address, attaching a copy of the complaint in this case and requesting acceptance of service. Nexon did not receive a response. On April 20th, 2023, Ironmace's U.S. counsel, Aaron J. Moss, responded to Nexon's cease.
Yeah, well, this is basically going over some stuff that we've already covered in the last video, so I'm going to kind of skip ahead here.
What they're trying to do is preface this by saying they have the ability to be able to make a rule that they can serve this stuff electronically if they want to. Service within the U.S. on Ironmace's counsel is not prohibited by international agreement. Hague Service Convention does not apply to service on a domestic agent of a foreign entity. So the point here is that the Hague Convention doesn't come into play when you're handing the attorney, if the attorney is located in the U.S., if you're handing the Korean party's attorney in the United States a copy of the summons, it's not going to violate the Hague Convention because nothing is moving internationally, basically. If valid service occurs in the United States, therefore the convention is not implicated regardless of the location of the parties. So in this case, there's no invocation of the Hague Convention because the Hague Convention isn't involved. Like many signatories in the Hague Convention, Korea prohibits service via postal mail by objecting to Article 10, which provides for the freedom to send judicial documents by postal channels directly to persons abroad. So, meaning that Korea does not allow for this to be sent directly to them. It must go through the Hagues to be verified, etc., etc. The Hague Convention does not expressly address email. The court and others have determined how...
This really sounds like a pain in the ass to try to get them mail.
However, that service by email is not prohibited even where signatories have objected to Article 10. Numerous courts have held that objection to Article X does not prohibit service by electronic communication. So what they're saying is that there have been multiple rulings saying that even though they won't accept it via direct mail, email kind of circumvents Article 10. This is because when sending service of process by email, there is no service by postal channels. Accordingly, the court concludes that service by email to parties located in Korea is not prohibited by international agreement. So there is no rule that exists that says that you can't send it via email according to Korea and international laws.
Okay, well, I mean, that'd be much simpler too. Just freaking send them an email, right?
They've agreed to. The same reasoning applies to direct messages on social media. Article 10 addresses postal mail service, not electronic means of service. A signatory country's objection to postal mail service does not prohibit service via electronic messaging systems. The court concludes that service by social media direct message is also not prohibited by international agreement. So this means that they can send a DM via Twitter with this case, document.
So that's easy. Why would you not take the route of just sending them a DM with this document attached to it versus having to go through the Hague Convention to send them a freaking letter? You know what I mean?
summons attached to it in a DM directly to the @Ironmace Games Twitter account, if they so choose, or they can try to email the individuals independently via direct email. I believe this will also allow them to send DMs on Discord to both Terry and Mr. Choi and SDF directly on Discord even. Circumstances requiring court intervention. In addition to satisfying the express conditions to obtain a court order, a plaintiff must demonstrate that the facts and circumstances of the present case necessitated the district court's intervention. And this is why I say that this isn't like a normal thing to be granted. So it has to be some kind of extenuating circumstance. In Rio, the court's intervention was necessary due to the plaintiff's inability to serve an elusive international defendant striving to evade service of process. In that case, the Ninth Circuit also noted that the Rule 4F3 advisory notes suggest that in cases of urgency, Rule 4F3 may allow the district court to order a special method of service even if other methods of service remain incomplete or unattempted. So in this case, they're referencing this prior case that says that they are allowed to serve them this way due to a sense of urgency. The sense of urgency in this case is that
I'm gonna be honest, I'm glad he's clearing that up because I have no idea what the fuck that meant.
Nexon believes that Ironmace is going to try and push this thing out to market prior to ever having to appear in court or respond, for that matter, because they were never given the summons. Here,
Right.
Nexon contends that this court's intervention is necessary because Hague's service may not be completed before the defendants plan to make the allegedly infringing video game widely available.
And what this is saying right here is they're trying to get this process sped up and get them in court because the documents may not reach them in time via mail postal service because it has to go through the Hague Convention. And they're afraid that due to that, Ironmace might get the game out before they get the document.
Now remember, they're saying allegedly infringing video game. None of this has been proven, but the Nexon saying that they have a sense of urgency the court believes to be valid and a good enough reason. Nexon contends the situation is urgent because it will be prejudiced if the game is widely released. This piece of it might seem a little bit silly about Nexon saying that they would be prejudiced against, but here's how the court in the United States works. And now, obviously, I'm not an attorney, so this is really like lay speak here, okay? But when it comes to summons, you don't have to respond to a court case that anything that you're being accused of. You don't have to respond to any of it until you've actually been served paperwork summoning you to court for the reasons outlined in the complaint along with the summons document. In this case, even though the DMCA request has happened, and obviously this is like very public and higher profile, and we've already seen the complaints and all this other stuff, Ironmace, until the point in time that they're actually served with the physical copy of the document, or the electronic one in this case, because this is what's being ordered, they could just claim that they didn't know about it. So if they push the product to market and it already ends up out there as a product that we're all like able to play and enjoy, then it becomes a much different animal in terms of court and how it would be perceived. Because they could have just claimed, well, we were never served paperwork, how would we know otherwise? So that's what Nexon is trying to avoid. So by getting this in their face as early as humanly possible, they can't just claim ignorance and say, well, we were just pushing it to market because how did we know? In an April 29, 2023 email, a firm that Nexon solicited to serve by means of the Hague Convention stated that they anticipate that we'll receive proof of service in 4 to 5 months after submission of the requests. And again, this is a document, an email that was provided as proof in the request that they had made. The longer end of that range would be approximately late September 2023. The Korean Central Authority indicated it would take 4 to 6 months at the earliest, which could be October
That's a long time.
2023 or even later. Given that Ironmace appears to be planning a wide release of Dark and Darker sometime between October and December 2023, and there is a substantial likelihood that Hague's service will not be completed before the release, the court concludes that Nexon has demonstrated an urgency that necessitates the court's intervention. So they are using statements that Ironmace had made based on Ironmace's own timeline to say, wait a second, we really need to have a talk about this before it ends up actually getting to market if their timeline is actually going to be met. For so Section C, due process. In addition to the requirements of Rule 4F, a method of service of process must also comport with constitutional notions of due process. To meet this requirement, the method of service crafted by the district court must be reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. Here, Nexon seeks to serve Ironmace by email to its U.S. counsel, Mr. Moss, at the same email address from which Mr. Moss recently sent email to Nexon. The dispute in this case is a current ongoing legal matter, the substance of which Ironmace's Korean and U.S. counsel have already communicated by email with Nexon regarding. Under the circumstances, the court concludes that email to Ironmace's U.S. counsel is reasonably calculated to apprise Ironmace of the pendency of this action. So in this case, again, it circumvents Article 10, and there's nothing that prohibits that from happening. So they're saying that they're going to end up sending an email to their attorney instead. When Ironmace receives notice of the suit through counsel, its highest level employees, such as Mr. Park as CEO and Mr. Choi as managing director, are highly likely to also be apprised of the suit. And then they reference a case, Brown, foreign individual defendants are current officers of China Integrated, and thus their close connection to China Integrated makes it all but certain that when the attorney is served through the company's counsel or its agent, they will receive notice of the suit. Meaning that it's not like their attorney isn't going to talk to them, right? The court concludes that service to Ironmace's U.S. counsel comports with due process for all defendants. So the court is saying by sending it to the attorney, that's good enough, and we have prior case law to fall back on to say, there's been a ruling about this already, and it's okay. Nexon also seeks to serve all defendants by email to contact@ironmace.com, the business email address provided on Ironmace's website. Nexon argues that such email is likely to apprise Ironmace as well as Mr. Park as CEO and Mr. Choi as managing director of the suit. Nexon also contends that sending email to Mr. Park and Mr. Choi at the email addresses listed on their business cards will provide additional assurances that they received notice of the suit. On March 23rd, 2023, Nexon sent a cease and desist letter to Mr. Choi's email address and received no bounce back notice, meaning that the email was valid, there was no kickback, there wasn't a domain failure. Mr. Choi's business email address has additional indicia of reliability, as Nexon's counsel states in a declaration that according to Nexon, Mr. Choi used his business email address to send an email to Nexon's CEO on April 26th.
So in other words, they're saying there's no reason that they shouldn't be receiving these emails. This email is valid, and that they should be able, and that it's and that they've been operating off this email prior.
27th, 2023. Nexon similarly argues that because defendants maintain active social media accounts that they use to promote Dark and Darker, communicate with their followers, and comment on Nexon's allegations against them, service by direct message to defendants' accounts is likely to result in actual notice of this lawsuit. Nexon has provided sufficient evidence that the three business email addresses are functional. Nexon has also shown that the defendants' social media accounts are active. The court concludes that the email to defendants' business addresses and direct messages to their social media accounts is likely to apprise defendants of pendency of this action and thus comports with due process. Accordingly, the court grants Nexon's motion to serve defendants by email to Ironmace's U.S. counsel, by email to their business addresses, and by direct message to their social media accounts. So, in triplicate, just to make sure their bases are covered, the redundancy of it all, it's going to the attorney, it's going to their personal emails or their business emails, and it's also going to be DM'd to them via Twitter, most likely, and possibly also through Discord. For the foregoing reason, the court grants plaintiff's motion. Nexon has leave under Federal Rule of Civil Procedure 4F3 to serve process by providing copies of the complaint, the summons, and this order, one, to all defendants by email.
And then it lists out their email addresses right there.
So it appears that there's going to be a court appearance within the next month, a preliminary one anyway. That also means that at some point in the next month, we're likely going to see an official response drafted by Mr. Moss and his associated attorneys on behalf of Ironmace to refute the allegations that Nexon is making. This whole thing is going to start heating up. It will be very interesting to see. I am sure there are going to be thousands of pieces of documentation entered into evidence, which I look very forward to reviewing with you all in the coming videos. Thank you so much for coming and checking it out. If you would be so kind as to follow me on my socials at OnePegMG on Twitter, at OnePeg on TikTok. Please consider joining up on Patreon at patreon.com/real_OnePeg. And as always, if you would be kind enough to sub the channel here, I would be very, very much appreciative of you all. Thank you so much for lending me your eyeballs. I love you all, and I will see you in the next one.
So there it is. They have been granted the notion to kind of fast track this case, which means we're going to be hearing from Ironmace within a month from now, and probably headed straight to court right after that, which means things are heating up, just like OnePeg said. And this is going to be very interesting stuff to cover. So make sure you guys stay tuned, because the more we cover this, the more interesting it's just going to get from this point on. That's it for today, guys. I'll see you on the next one. Hey guys, if you like the video, make sure you head over to the page, hit that like button, scroll over, smash that subscribe, and hit that bell icon to get notified for future video drops. And I will see you guys on the next one. Thanks for watching.